June 2025, the government announced plans to proscribe Palestine Action as a terrorist organisation. This followed a break-in at RAF Bryce Norton, during which they spray-painted the turbines of 2 aircraft. Since then, police have arrested over 2,000 individuals at various protests across the UK for expressing support for Palestine Action. In October, the Court of Appeal ruled against the government's attempts to block a legal challenge to the proscription of Palestine Action, meaning that we'll soon get a court judgment on the legality of this decision to ban Palestine Action. In today's episode, I'm joined by 2 experts on counter-terrorism law in the UK to discuss what proscription means and the process around banning proscribed organisations, whether Palestine Action is different to other groups that have been proscribed, and what are the legal and political consequences of this proscription. What does this tell us about the state of human rights, democracy and the rule of law today? I'm delighted to be joined by Dr Daniella Lock and Professor Colin Murray. Daniella is a lecturer in law at the Dixon Poon School of Law, King's College London, and Colin is Professor of Law and Democracy at Newcastle Law School. And I suppose I should probably introduce myself too. I'm Alan Green and I'm a reader in Constitutional Law and Human Rights at Birmingham Law School. So, how are you both today?
Hey Alan, how you doing?
I'm doing good. How are you, Daniella?
Yeah, very well, thank you. Very excited to be here on your podcast. Thank you for having me.
No, thanks for having us, Alan.
Great. The as yet unnamed podcast. Okay, so let's get into it. I touched upon it at the start, but it would be good to dive a little bit deeper into the issues. But who exactly are Palestine Action and why did the government take the decision to ban them in the first place?
So, I suppose if I dive in there, Palestine Action are probably best described as a direct action protest group. They are trying to raise issues to do with Palestine, the treatment of Palestinians and Israel's conduct both before and after the start of the current Gaza conflict, and raise its salience and its profile within debate in the UK. It goes beyond the conflict immediately and what should the UK government's response to that be. It runs into boycott and divestment and also direct action against Israeli arms companies in particular operating at sites in the United Kingdom. So what do we mean by a direct action protest group? This is a protest group that seeks to get media attention for its cause by acting in a disruptive way in protests. This might involve, as it did in the Bryce Norton incident, a break-in to a military base. It might involve damage to property, like spray painting the engines of military transport aircraft. But to say it goes beyond that is almost to move away from the point of this protest group. The idea is to get attention. And I think there's often been a dividing line between how we think about coming into a space like an airbase and causing damage by spray painting and what would happen if someone that actually did have terrorist intent managed to get onto a base in this way. Would we really think someone where you close your eyes and think of as being someone engaged in political violence and seeking to cause that level of harm, would they really have come armed with a spray can and used that as their mode of doing damage? Damage is a way of getting attention, of performative action, as opposed to things that either cause a threat to life or, lasting harm in terms of explosives or in terms of gun attacks. Those would be the modus operandi and the aims that Palestine Action have been pursuing.
Excellent. And so just in terms of then the justification for proscription, why did the government take this decision? What was the threshold that they thought that they crossed?
I suppose if we start on why it took the decision, clearly when protesters are able to break into a supposedly secure airbase, there is a level of embarrassment that exists for the state at that point and a need to be seen to be doing something in response, a need to be seen to be taking this activity seriously. But then that shades into the question of why reach for proscription and a counter-terrorism response in this context. Again, if the actions of a group like Palestine Action can be said to be performative, well, so can the UK government's actions in this regard. They want to be seen to be taking this issue seriously and to be on top of a problem. But that brings us into a lot of questions we're going to look at this morning about how does this fit within the definition of terrorism, and how does it fit within the banning of groups and the legal regime that's put in place for doing that.
So Daniella, just in terms of there is a court case now pending, and we're waiting for the judgment to be handed down soon. Can you just give a bit more of an update and a bit more of a background into this case?
Yeah, sure. So there are two potential legal routes to challenge the lawfulness of a proscription decision. The first is to do ordinary judicial review. You go to the ordinary courts, and as Palestine Action has done, gone to the High Court and challenged the proscription order on a number of grounds, including that the order doesn't comply with the government's obligations under human rights law. It doesn't adequately protect human rights. The other legal route, and I think we'll discuss in a little bit more detail later on what the kind of key distinctions between these legal routes are, but the other legal route is to go to the Proscribed Organisations Appeals Commission, which was an organisation set up specifically to examine the lawfulness of a decision by the government to refuse to deproscribe an organisation. So the way this legal route is supposed to work is that once there has been a prescription, you can apply to the government to have that organisation deproscribed, and then if the government refuses to do that, there is this specialised judicial body that you can go to challenge that decision. Now, a key question in the legal proceedings so far in the ordinary judicial review route has been, is it appropriate for there to be a judicial review when there is this alternative specialised legal route? One of the key questions and findings of the judicial review proceedings so far has been to say, well, actually, it is appropriate to take this ordinary judicial review route for a number of different reasons, including the fact that this specialised legal route doesn't actually provide any remedy for people who've already suffered criminal consequences on the basis of the prescription that's happened so far. And so it's this month that we have legal proceedings. The High Court is going to be considering in full whether or not the prescription order is compliant with the human rights obligations of the government.
Which I suppose brings us neatly into, well, how did this whole story start? And if we're talking about this group and the banning of it, prescription of a group doesn't work without that group first fitting within the definition of terrorism. And Alan, questions related to the definition in UK law and how it functions, well, that lies squarely within your area of research expertise.
Yeah, so I've recently just done a study in which I did a survey of the UK's counter-terrorism legislation, and I found 652 different statutory provisions that are dependent upon the UK's definition of terrorism. So this definition really is like the keystone to everything that flows from it. And the way it's defined is incredibly broad. So it's Section 1 of the Terrorism Act 2000, and it essentially defines terrorism as the use or threat of an action that's designed to influence the government or to intimidate a public or section of the public. And then that action has to be for the purpose of advancing a political, religious, racial or ideological cause. But in terms of then how action is actually defined, it's defined incredibly broadly. It includes things like serious violence against a person, which is what an ordinary person would expect terrorism to cover. We all have in our heads what terrorism is. We think of maybe bombings and shootings, etc. But the definition then also extends to serious damage to property too. It can extend to actions that endanger risk to a person's life, or can create a risk to health or safety of the public, or action as well that is designed to interfere with an electronic system. The problem with this is just the sheer breadth of this definition, and in particular this idea of serious damage to property, which the definition covers. Now, you can see why they included that in the definition. Imagine you had a bomb that went off and it only damaged property, that wouldn't be covered. However, that idea of serious damage is really vague, and it's on these grounds alone, essentially, that Palestine Action have been prescribed, because it's been claimed, particularly if we look at the break into RAF Bryce Norton, and there's a dispute as to the amount of the financial damage actually caused by spray painting aircraft, but essentially the claim is made, well, that constitutes serious damage to property. Likewise, the damage that they've caused to arms factories as well, that's considered to cross the threshold to amount to terrorism, and the government's decided to ban it. But really what this shows, I think the breadth of this definition, is that we're really dependent upon decision maker discretion to decide who to prescribe or not, or who to label terrorists or not. And lots of actions could potentially meet this definition, but the government or the police exercise their discretion and say, we're not going to call it terrorism. So, for example, in the past, you had certain protest groups, certain animal rights protest groups, for example, that did far worse than what Palestine Action have done, but the government nevertheless took the decision, we're not going to prescribe them, because of the broad support, maybe not for their actions, but for the general cause of preventing cruelty to animals, preventing animal testing. And it was thought that it would just be completely counterproductive to prescribe these groups. But likewise, certain environmental protest groups could meet this definition too. And the government, for the time being at least, and the police, for the time being at least, have decided we're not going to extend a counter-terrorist framework to these organisations. But ultimately, this means that really the definition of terrorism isn't really a meaningful constraint on government power. Really, we're relying on how they use that discretion. I think a really good example of just how broad this definition is if you look at it applies to actions not just against the British government, but any government overseas as well. And so what this means is that the definition potentially applies to any organisation that is involved in political violence against another government. And that includes organisations that the British government themselves support. And it potentially even covers the armies of other states too. And the independent reviewer of terrorism legislation, David Anderson, has flagged this up, it could even potentially apply to British armed forces themselves, which is insane when you think about it. But what this means is there are so many groups out there that the government says are not terrorists, but legally they meet their definition. And it means it's down to the government, it's down to the police to filter out and make their own subjective decision as to whether we prosecute this individual or not prosecute this individual. And Palestine Action is kind of that's bringing all of this discretion home and actually making the public for once actually think this might be a problem.
So if this case is bringing it home to the public, Alan, have the courts grappled with this level of discretion that's been given to the government up to this point in their dealing with questions of prescription?
So, in any case law to do with the definition of terrorism, the courts have at times been quite critical of this definition. So, for example, in the Ghoul case back in 2013, which was to do with an individual uploading videos on YouTube praising the actions of the Taliban, etc. And the government, that individual tried to argue that the definition was too broad and should exclude actions that occur during international and non-international armed conflicts. That's for international humanitarian law to apply. It shouldn't be for terrorism law. Tried to make that argument. But the court basically said in the UK legal system, where essentially we've got parliamentary sovereignty, the courts basically said, we don't like this definition. It's far too broad. Relying on this decision maker discretion to kind of temper or mitigate the breadth of this definition, the court said that's not legitimate. However, they also said there's nothing we can do about it because this is for Parliament to fix. Under the British constitutional system, courts tend to have quite a constrained role. It's for Parliament to fix it, and Parliament has not done anything since, and that was over 12 years ago. So that's kind of like just a broad overview of the definition of terrorism. It covers lots of different problems, but maybe it's better if we zoom back in again to the definition in the particular context of proscription. And there are problems not just with the definition, but with the proscription regime itself, kind of long-standing problems. I'm wondering, Colin, if you could just unpack that a little bit more for us.
Yeah, of course, Alan. And I suppose these two things go directly together. The breadth of the definition is almost like a key. It opens up lots of different doors of counterterrorism policy. And one of the doors that it unlocks is this ability to ban groups because of their involvement or their connections to political violence. Now, this is the archetypal look tough policy of UK counterterrorism law. It's often described as being symbolic. It's often said to be a really long-standing counterterrorism power. The origins of banning groups in UK law goes back centuries into 19th century measures used in relation to Ireland. But what's really important to remember about it is it very rarely produces convictions up to this point. It's designed to what represents societal outrage over the use of violence towards political ends, and to symbolize that the state is doing something in response to that, so that vigilante groups or conservative or reactionary groups that are reacting against another group using political violence don't emerge because the state isn't in this space. But the very nature of terrorist groups as clandestine organizations means that there are often very few direct associations between someone and a group. There isn't, as it is famously said, a membership card for being part of a banned group. And there is very rarely any paraphernalia associated with these groups. These groups are not like direct action protest groups. They're not trying to attract public attention. So terrorist groups generally want to go below the radar, at least until the point where they are able to perpetrate attacks. That's essential to their very existence. The whole idea of proscription is to try to take these groups out of the public sphere, to remove them from a public space, and to signal to members of the public that they shouldn't associate with these groups, that these groups are beyond what is acceptable in a democratic society. Now, even for genuine terrorist groups, that mode of state activity has problems. If a group is organizing openly, well, the state and its security agencies can see that organization and they can see who's becoming involved in it and can track its linkages, potential radicalization around that group, and can infiltrate the group relatively easily and understand its planning. As soon as a group is banned, this drives a group underground. So, as Conor Gerty would have said, even when proscription is correctly targeted, it is a double-edged sword. It has effects that make it more difficult for the state to pursue certain aspects of counterterrorism policy. But worse than that in a UK context is the nature of what groups can be banned. It doesn't just connect to groups that are directly involved in political violence. The idea of proscription has been augmented in multiple phases, particularly from the Terrorism Act 2000 onwards. So it now covers groups that are said to be promoting political violence. And more than that, it covers emanations out of those groups. So if a group changes its name, but is substantially the same group, under Section 3 of the Terrorism Act, that remains a banned organisation. And the result of that is that for the ordinary general public, it's very hard to know the boundaries of proscription. It's very hard to understand, is the group that I'm dealing with the same one as one that's on the banned list? Or should I just stay away from whole issues that seem to be associated with groups that government are banning, and even by associating with people that might be connected with those groups? Do I potentially put myself on the radar of the state or in line for punishment? Proscription takes us into a space almost of guilt by association. In ordinary criminal law, it's not who you hang around with, but it's what you do that makes you the legitimate subject of criminalization. It's your actions and your personal activities. You can hang around as many quote unquote bad people as you like, or people the state don't like as you like, but unless you are involved actively in some wrongdoing, well, then you're on the right side of the law. For proscription, the mere membership of a group, or the mere having paraphernalia associated with a group, or attending meetings which are arranged by a group, all of those things that are on the periphery, or maybe at one stage of remove from the direct political violence that the state is said to be dealing with, are all brought within the ambit of criminalisation where prescription's at issue.
So I think what you're talking about there is it's this classic example of the government just and the state kind of casting its net as wide as possible and maybe not concerned about what those consequences are, say, for human rights or the rule of law. But interestingly as well, what you suggested there was, and building upon Conor Gearty's work, is the idea, well, when you ban something, you drive it down and you drive it secretly. So in a way, then, that makes it harder for the state to do its oversight. So this idea that there's, and you'll hear it all the time, that there's, we need to sacrifice rights to increase security. Kind of what you're saying there is a great example of, well, actually, those two things don't often go hand in hand. Very often you can bring in a measure that's supposedly in the name of security, but actually ends up potentially making it more difficult for the police to do their jobs. And so when we look at the banning of Palestine Action, and when we look at the some 2,000 or so people that have been arrested as a result of that, that does raise the question as to whether this is actually helping or hampering the police in terms of what they're doing and in terms of their allocation of resources. So maybe if we can maybe unpack a little bit more about the national security ramifications of the banning of Palestine Action in particular, that would be really interesting to hear more about.
Well, that's a great point to kick off on, Alan. If we look at any recent year, the number of terrorist arrests or terrorism-related arrests has been in the low hundreds. And if you looked at the number of those arrests that are linked to the offences connected to proscription, membership of a banned group, demonstrating or giving support to a banned group, or wearing or displaying paraphernalia associated with a banned group, you're probably talking about a number of arrests, let alone convictions, on the fingers of two hands at most in recent years. And now suddenly, with the banning of Palestine Action, we've seen thousands of arrests that are having to be processed. And that in itself, it comes back to, well, this symbolic idea of looking tough in a security space, and what are the costs of that for the state? Because suddenly it's going to look ridiculous when the statistics come through of counterterrorism. The incredible spike in counterterrorism activity that went on from the summer of 2025 onwards is going to look like we are living in the most dangerous time to have been in the UK in recent decades. And we're not. We're just seeing the outworking of a policy that ascribes this label of terrorism to lots of activity. And I suppose if we take your earlier point, Alan, about discretion and the amount of discretion that's baked into the definition of terrorism, there's a double bite of discretion when it comes to banning groups. So the definition of terrorism under Section 1 of the Terrorism Act 2000 then sets up the powers to ban groups under Section 3 of the Terrorism Act 2000. And for the Home Secretary to add a group to the list of banned organisations, what they have to submit is some subjective belief that that group is in some way concerned in terrorism. That's the basis on which they can bring forward a prescription order. And then at that point, they need to persuade Parliament that that threshold has been met. But if you like, that's an incredibly low proof threshold to be met in this context. I could say that I believe a lot of things, but a subjective belief that a group's involved in terrorism mightn't stand up to any sort of objective balance of probabilities assessment, the civil standard of proof, let alone an idea of certainty that a group is involved in terrorism. You could believe a lot of things with relatively little evidence to back that up. So again, when the Home Secretary comes before Parliament and says, I want to get this group banned, what level of evidence ever needs to be put forward to back up that case? The law requires a vanishingly little evidence to be presented to MPs. And so you get this double bite of discretion. Not only is the definition very broad, but what the Home Secretary has to do to satisfy the tests under the Terrorism Act to ban a group is a really low hurdle. The Home Secretary's belief that a group is concerned in terrorism can be founded on the basis of its activity, but they don't need to show very much activity at all, or anything that's out of the run-of-the-mill of ordinary, say, what could be an ordinary crime, can be bundled in with security assessment or nods towards security assessment, security-sensitive information that cannot be presented before Parliament to give a picture of a group as being dangerous. And then all that the Home Secretary is doing is asking the House of Commons to back up their perspective. And that's a really difficult place for MPs to be in, because the Home Secretary is coming before Parliament saying, my job is to keep people safe. And I have special security cleared information that says this group is a particular threat. And Yvette Cooper did this in the context of banning Palestine Action, said, for want of a better description, what I know about this group would make the hairs on the back of your neck stand on end. There was this sort of a pitch around the group for a ban, but very little of the group's supposed threat beyond what actively had already happened at sites like Elbit Systems or at Bryce Norton was actually part of the case that Dan Jarvis put before Parliament. So, if you like, a security imperative. We know secret things, and we need the backing of Parliament to keep people safe, drives the prescription case. And what often gets it through Parliament is quite simply party loyalty and the fact that the government commands a majority of the House of Commons, by definition, to be able to be in government. It must be able to command the support of Parliament on major issues. And a combination of those things can restrict any parliamentary scrutiny of what's going on here.
So Daniella, if I were looking at the legislation and if I were just coming to the British Constitution and I would say, oh, the House of Commons and the House of Lords have to approve the decision of the Home Secretary for a group to be prescribed. In my head, I would think, oh, that's a great democratic safeguard. Surely that's going to act as some constraint on this decision of the Home Secretary to prescribe a group. What would be wrong with that assumption? And why, in the case of Palestine Action, was Parliament ultimately convinced, as Colin is telling us, that yes, no, this group does need, in fact, to be prescribed?
Yeah, great. Thank you, Alan. Yeah, it's a really important question. And I think this is a really important piece of the story from the perspective of how far Parliament was able to properly scrutinise the extent to which a prescription case had been made with respect to Palestine Action. So, as we've just heard from Colin, there is this kind of ambiguity as to what is Parliament's role in approving a prescription order, because the legal test set out for prescription is related to the belief of the Home Secretary. While that's the case, I think that there's, Parliament having to approve the prescription order in the first place does make it a safeguard within the legislation to ensure, as one means to ensure that prescription powers aren't abused, that they aren't used as a political tool for the governing party. It's contained within the Act that it's Parliament who makes the decision on prescription rather than the government ultimately. And, what you would think would reasonably go hand in hand with that is that Parliament would have the ability to make some informed decision on the circumstances around prescription, that there would be some independent democratic scrutiny of the case for prescribing Palestine Action. And I think there are three factors which related to the way that the prescription order was passed, which seriously undermined Parliament's role in conducting even a basic level scrutiny of the case for prescribing Palestine Action. So the first relates to the timings of the prescription. So there were just a matter of weeks between the announcement by the government to prescribe Palestine Action and parliamentarians being required to vote on the prescription. The debate time in the House of Commons was limited to 90 minutes, and the debate time was under 2 hours in the House of Lords. So while this isn't massively out of step with previous timings for prescription, there was a very strong case for there to have been extended time given to parliamentarians to debate prescription, given the absolutely exceptional nature of this prescription, which we've already been hearing about. Previous prescription orders, the debates on them didn't need to be that long, partly because they've been nowhere near as contentious. As we've heard, this is the first time that a group has been prescribed where the group is engaged in serious violence to property rather than in relation to persons. This is also the first time when a group has been prescribed where, by the Secretary of State's own assessment, that group has domestic support up and down the country. Yvette Cooper, Home Secretary at the time, she said and emphasised that the group had a footprint in all 45 policing regions in the UK, and as we've seen, the amount of people who have been willing, the thousands of people who've been willing to get arrested under terrorism law in support of Palestine Action shows that this is an absolutely unusual case. It was always going to be of huge democratic concern to people up and down the country, and that forms the basis as to why Parliament should have been given an extended period of time to debate this particular prescription. We also know that the prescription was always going to have widespread ramifications in terms of affecting people's rights domestically, partly because of this support that it has on the ground. The timing is an issue. I think that there were parliamentarians who would have appreciated much more time to consider and go through lots of the different implications that could have been raised by this prescription, and also the implications for national security, as Colin was talking about. There was always an obvious case from the beginning of the prescription that prescribing Palestine Action could actually be counterproductive for protecting national security. And as we've actually seen, where there have been actual terrorist attacks, where there have been violent attacks against people since the prescription of Palestine Action, and the police have complained that they haven't had enough time and resources to go and see to those events and those problems because of the amount of time and resources they're spending on basically arresting, let's face it, mainly pensioners who are sat around Parliament Square peacefully holding a sign. So these exceptional circumstances mean that we would have ideally had more time for parliamentarians to consider these issues. Another fundamental problem with the way that the prescription order was presented to Parliament, and which in some ways I think some parliamentarians describe this as a quite cynical means to kind of coerce parliamentarians into rubber stamping the prescription order, was the fact that the prescription order didn't just have Palestine Action listed on it. It had two other organisations also listed on the order that were clearly violent terrorist groups. Proscription orders can't be amended. So if parliamentarians were going to vote against that order, then they would also be voting against proscribing these two very obvious terrorist groups who were likely to be a threat to national security. So the actual form of the proscription order put parliamentarians in the position that if they voted against proscribing Palestine Action, they would actually be at risk of harming national security. And you've really got to ask a question about what that says about the case for proscribing Palestine Action when the government was prepared to shield scrutiny of the proscription that way. I think it also raises questions about even this more subjective element of the Home Secretary's belief in the idea that the Palestine Action was a terrorist group. If she had in fact had a belief that Palestine Action was clearly a terrorist group, then why would the proscription order be set up in this way such that parliamentarians really wouldn't be in a position to exert independent scrutiny? There's also issues around the information that was given to parliamentarians at the time of being required to vote for that prescription. So the Home Secretary didn't include a proportionality assessment when she presented the prescription to Parliament. And this is key because it is probably the fundamental safeguard attached to prescription powers, which is that in order for prescription to be lawful and compliant with human rights, the decision has to be proportionate. And that means that basically there has to be no less intrusive means of dealing with the problem posed by Palestine Action, no less intrusive measures to human rights. There's nothing else that the government could have done to respond to the issues raised by Palestine Action that would have been less harmful to human rights. And it's a really important balancing assessment which is included as a safeguard within prescription powers. It's quite fundamental to any assessment as to whether or not Palestine Action should be prescribed. That assessment is done. It puts parliamentarians in a very difficult position if the government isn't even prepared to present its own proportionality assessment. I think that left parliamentarians in quite a kind of confused position. And then there's also this issue around the intelligence assessment. So obviously parliamentarians themselves, if there is security sensitive information which the government feels it can't disclose because it would harm national security, for it to give the true reasons as to why Palestine Action would be prescribed. Though interestingly they didn't talk about an intelligence assessment right at the beginning of prescribing Palestine Action. The government only spoke about not disclosing information on the basis that it would jeopardize legal proceedings that were current criminal proceedings. The intelligence assessment, it would be understandable if it wouldn't be disclosed to the broader public. However, you do have a specialised parliamentary committee, the Intelligence and Security Committee. The parliamentarians in that committee, they are constitutionally required to scrutinise national security actions by the government, and they have security clearance. They have the ability to hear evidence in secret, and they are security cleared parliamentarians. And yet the government refused to even provide the intelligence assessment as to why Palestine Action constitutes a terrorist group to the Intelligence and Security Committee. And as far as I know, they've still not provided parliamentarians with the intelligence assessment. I have tried to find out, but this was an issue that was raised by the Joint Committee on Human Rights just a month or so ago. I think what you have there is three factors related to timing, form, access to information, which really put Parliament in the position that it was not able to conduct even just a basic level of scrutiny as to whether or not that prescription order met the kind of legal framework as required.
That's really interesting and quite worrying as well. You would think that in a political constitution system where the best assessors of what rights versus the common good require is Parliament, but Parliament isn't being given the tools necessary to do what it's supposed to do, and also whether, even if it is given the tools, whether it actually want to do that job. But I think you hit on something I find really interesting there as well, about the police now saying that they don't have the resources to actually police some of these protests, and I found, but also mentioning when there was actually a legitimate terrorist attack that did occur, and then you saw the government conflate that attack with the protests and saying these protests can't go ahead because it will stop the police from doing their job in protecting group. Like, I found that quite stunning, to do that conflation, but also potentially self-undermining the government's own claim that these protests are somehow terrorist offences. That we ask the terrorists nicely to stop protesting just does not make any sense to me. But just in terms of the protests and then the subsequent sheer numbers of arrests, that kind of leads us nicely to just discussing about what the actual consequences of proscription are. So it's not just that the government declares a group unlawful and that they're a very naughty group and you shouldn't join them. There are quite serious consequences that flow from those. Colin, could you explain a bit more about the legal consequences that flow from proscription?
Yeah, so this is the what do you win if you manage to get a group banned? And so far, we've talked about, well, how easy it is for the state to use these powers to ban organisations, the sort of double dollop of discretion that comes with the very broad definition of terrorism and the idea that a group to be banned, the Home Secretary just has to move a ban on the basis that of a belief that they're concerned in terrorism. But it's not simply that the Home Secretary is leaning heavily on concepts like damage to property or threat to life, and is leaning on security assessments. The really key thing to understand when we're talking about just the sheer numbers of people that are arrested is that the law itself has changed from when the Terrorism Act 2000 was drafted and moved. The consequences of proscription and the offences that flow from it have been radically extended since this act came into being. So an act that came into being with very few safeguards in practical effect now has greater consequences when government finds its way past those limited safeguards and puts a ban in place. If you're involved in some way with a banned group, there is a trifecta of offences that can be used by the authorities in relation to someone. An individual who's connected to a banned group does not need to be shown by the authorities to be directly involved in terrorist activity, to be themselves involved in a gun attack or a bomb attack, or even themselves involved in breaking into an RAF base or a defence company. When you ban a group, the whole idea is that you suppress any ability of those groups to organise. So you ban the mere membership or claims that someone's a member of a group, because that's a way that the group shows its strength in society, or maybe provides a pool of people that it could draw upon to carry out future actions. You ban shows of support for a group, and you ban the display of any imagery associated with a group. Those were all in place in 2000 when the Terrorism Act was put in place. They are all holdovers from the way proscription worked with regard to the top-down, heavily structured and organised groups that were related to the conflict in Northern Ireland. But they've all been subject to subsequent cases, and in many cases have been extended. The two cases that I think we need to draw attention to are the Chowdhury case and the Power case. The former case, Chowdhury, concluded that under Section 12 of the Terrorism Act, providing support for a terrorist group didn't just entail providing material support. You provided a safe house or you funded in some way a group, but it also involved throwing your personal moral weight behind a cause. That was enough to meet the threshold for support. And then subsequent legislative action took that judicial account of what support is and baked it into the statutory rules around the Section 12 offence. And then under Section 13 and the Power case, well, that case made it clear that showing imagery or paraphernalia that linked to a banned group only has to trigger a reasonable suspicion that you were seeking to associate yourself with a banned group. And that reasonable suspicion is from an external observer. There doesn't need under power to be any intent element for the person doing the display of clothing or paraphernalia. Now, what that means in combination is that there is a vanishingly small set of safeguards in those offences with regard to expression or association rights. It essentially means that now the holding up of a mere placard with text to the effect of "I support Palestine Action" is enough to trigger the offences that are consequent upon proscription of a group. And so it's not just that there are very few safeguards around putting proscription in place, it's that the consequences of proscription have grown through this jurisprudence and through these additional statutes that have amended the Terrorism Act 2000, as governments have sought to show we are responding to the threat of terrorism. That's, if you like, expanded these powers and made it the case that so many people can be arrested off the back of a mere placard.
Yeah, and that issue about how you don't actually have to declare support for the organisation, you just have to give rise to a reasonable suspicion that you support it. Like, we've seen some quite extreme applications of that. If I remember, someone was arrested and they claimed the reason they were arrested was because they held up a placard, not saying that they supported Palestine Action, but saying that they opposed the proscription of Palestine Action. But that was considered to be, by the police that was doing the arresting, considered that to be enough to issue, to decide that I'm going to arrest this person. We've also seen the police arrest and then subsequently de-arrest and apologise someone going to a protest carrying a Palestinian flag. Now, that's a very, very extreme example of it, and ultimately, again, they did issue an apology, but still, they're in the position where you don't actually have to fully declare or even write your declaration of support. You just have to give rise to a reasonable suspicion that you do support that group. So it's deeply, deeply worrying in terms of just the sheer breadth in which these powers entail. But that brings us neatly, I think, to this issue that Daniella, you touched upon earlier about.
Yeah, thank you. So, as mentioned, this is the proportionality assessment is the key test that needs to be met in order for the proscription to be compliant with human rights and the obligations on the state. And this to meet this test, there have to be means no less intrusive to human rights which are available to the state to deal with the problems created by Palestine Action. As part of meeting that test, the state also has to show that the public interest in dealing with those problems actually outweighs the harm to human rights that will be caused by that prescription. So, as we already know, the Home Secretary didn't actually present an explicit proportionality assessment when Parliament was required to vote on the prescription. At first glance, there seem to be an array of powers that the police already have in order to tackle whatever problems it is that may be caused by Palestine Action and the kind of activities they were engaged in. So, we already know and we can see that there have been lots of people put on trial for when it comes to the actual damage, the criminal damage imposed by Palestine Action in relation to armaments factories and in other environments. There is clear criminal law. It's very easy to apply. There are Palestine Action people in prison already where they've caused criminal damage. There are also conspiracy offences that can preemptively hold people criminally liable for assisting people about to cause criminal damage. So, even before the actual action has been carried out, there is actually an array of criminal offences that can be applied, if the state really, needs to urgently intervene with regards to Palestine Action protests. I do note that the Independent Review of Terrorism legislation currently, Jonathan Hall, he wrote a piece saying that the conspiracy offences may not be sufficient for tackling things like funding of Palestine Action, but he didn't really go into detail on this, and to me it's not clear why the state would need to intervene against funding Palestine Action, what the actual act of funding Palestine Action, what the problem with that is from the perspective of national security. It seems to me that if the issue is about what Palestine Action is actually doing, then why wouldn't those conspiracy offences be sufficient from that perspective? I mean, and if they're not enough, there's also this extra legislation that the government passed recently contained within the National Security Act 2023, which expressly gave military sites as well as the locations of arm manufacturers that aren't even part of the British state. It gave the government powers to assign them this protected status, refer to them as prohibited places, where essentially to kind of interfere with these sites actually counts as foreign power threat activity, and has this kind of all these kind of ramifications from the perspective as being seen in the eyes of the criminal law, but also with regards to kind of preventative counter-terrorism powers, national security powers. The act of assigning somewhere as a prohibited place gives that location particular protections, which you would think would be exactly the kind of powers that would be relevant for preventing the kind of direct action that Palestine Action was engaged in. And the fact that these powers exist, and with the National Security Act, the fact that this was passed so recently and so obviously relates to the locations where Palestine Action is operating, you'd think that that would create a clear grounds for the government to be telling us expressly why these powers aren't sufficient. It's such an obvious counter argument to the proportionality, to the idea that the proscription order is proportionate, that I'm struggling to see why the government didn't engage with this precise issue. So at first glance, the government already has an array of national security related powers to respond, and criminal powers to respond to the behaviour and the tactics of Palestine Action. There's also, the government provided no assessment as to how the public interest in dealing with these problems raised by Palestine Action outweighs the harm to human rights caused by the proscription of Palestine Action. Indeed, the government has not provided even a kind of meaningful assessment as to what kind of harms would be implicated in the proscription of Palestine Action, even though it was clear right from the beginning that it was going to affect so many people in the UK, and that there was going to be a backlash to this prescription that would then extend these counter-terrorism powers to, such a broader, it's an unprecedentedly broad category of people now that are being arrested for terrorism offences. It's not like anything I think we've ever seen in the UK before. And so, given that was probably quite predictable, it's strange that the government did not even provide an assessment as to the harm that the proscription order was going to potentially entail in relation to human rights. And, as a consequence of not providing that assessment, it seems it's just not clear whether the government anticipated that what would essentially be a clear consequence. We've already heard from Colin about all the kind of broad consequences of the prescription that the prescription has already entailed. But just to go in a bit more detail, it has involved the forcible removal of individuals such as, pensioners and, including disabled pensioners, people who are in wheelchairs, people who have, their walking stick, being forcibly removed, put into police vans where they have refused to give their information. They've actually been kept in cells overnight. And with the courts already clogged up, it's not clear when they are going to be able to, those that are charged, when they are going to be able to get their day in court. And so they've got a huge amount of uncertainty about their future at the moment. And then that's not even to mention, the stuff that's happening behind the scenes in relation to human rights as a result of this prescription. We do know that there are members who have been directly involved with Palestine Action who have, already had visits from the police. We don't know what surveillance powers accompany prescription. So does the fact that a group is prescribed give the government and the security intelligence agencies grounds to seek ever more broad surveillance warrants in relation to anyone who might be associated with Palestine Action, anyone who has written about Palestine Action on the internet, even potentially academics who talk about Palestine Action. That there's a potentially very broad category of people whose human rights are being actively interfered with because of this prescription in a way that I don't think I can't think of a comparative measure that's been enacted domestically here in the UK that's in recent years. And so the fact that the government hasn't provided this assessment, or let alone balanced it with the potential harm to national security that it's supposedly reducing by prescribing Palestine Action, suggests that the proportionality assessment has either not been done, or when it has been done, it hasn't necessarily come out with a favourable formulation. Obviously this will be considered in detail in the courts, but unless there's dramatically new information that we haven't heard about before, from everything we have available at the moment, the issue of proportionality seems to be where the government is potentially at its weakest in terms of the case for prescribing Palestine Action.
That's really interesting and really worrying, and I think you can see then why people are taking a challenge to the courts to challenge this decision to prescription. I'm just wondering though, why did they decide to go through the ordinary judicial review process rather than using the Proscribed Organisation Appeals Commission? So the word appeal makes it sound a little bit more like it's much more substantial inquiry than your classic straightforward judicial review. But that name is perhaps a bit of a misnomer, is it?
Yeah, so for some people, I think they felt that going to the Proscribed Organisations Appeals Commission could be more beneficial from the perspective of having kind of a more rigorous judicial analysis of the government's case, and a more engagement with the closed factual material, and the actual factual basis for prescribing Palestine Action. At the same time, and compared to ordinary judicial review, which is often quite process-based, it will often look at whether or not the decision of the government was reasonable and try and stick within the reasons for the decision rather than making a more objective, substantive legal assessment. For some people, that's what made the case for going to the Proscribed Organisations Appeals Commission. However, there are several limitations with POAC, the Proscribed Organisations Appeals Commission, which means that it doesn't really provide an adequate remedy for prescription in this context. I think originally it was seen as an important judicial safeguard where in cases where the circumstances of an organisation had changed and the government had refused to recognise those change in circumstances and deprescribe that organisation. But it doesn't really work very well when the prescription right from the beginning is unlawful or is inadequate. So the prescription order itself, POAC has no power to actually quash that order. And so from the perspective of all the people who've already been arrested, they don't actually have a remedy. They can't actually say that the law under which they were arrested shouldn't be applied. And so it creates all this uncertainty about what happens to all of those people who've already been arrested under the prescription order. There's also the issue of timing. I mean, if you have to wait to apply for deprescription from the government, and then the government has all that time to make the decision, and then you have to wait in order to bring that appeal of the refusal to deprescribe, that's just a much lengthier process than ordinary judicial review. And thankfully the courts have said that this ordinary judicial review can go ahead.
Yeah, and I think that then judgment is going to have quite a substantial knock-on effect to not just Palestine Action, but potentially any other direct action protest group, of which Palestine Action is just one of them. So what do we think if we're looking at the future? Does this just mean that we're looking at kind of a carte blanche? It's an all-out government war on direct action protest. Democracy just means maybe the most extreme thing we can do is write a nice letter to our MP asking them to reconsider a thing.
I suppose to reaffirm the significance of something that Danielle has made really clear already, this is not a situation where if the government loses that case and the ban on Palestine Action is quashed as being unlawful, that the government has no tools. Direct action protest, from the suffragettes to Just Stop Oil, involve making a point by people being willing to subject themselves to the criminal law. The whole notion of direct action protest involves getting attention to your cause by potentially committing crimes to flag what you see as being greater wrongs that are being committed in society. And as Daniella has said, it's not that there aren't a whole range of applicable public order offences that are in play here, and that they've been augmented by really recent legislation like the National Security Act to deal with just this sort of activity. It's the huge problem is that the government, even with all of that legal architecture for dealing with this sort of activity, have also seen fit to bring into play counter-terrorism law with all of the particular chilling effects around pro-Palestine activism that can come with that, and to apply it in this sphere. Even if this case is won, that doesn't mean that there will not be a criminal case advanced against those that were involved in the Bryce Norton break-in. That is being pursued, and that break-in was before the ban on Palestine Action. There were always mechanisms that government could have used to tackle this. It's just that they have chosen to, if you like, have their cake and eat it too, have an incredibly extended public order regime, and also bring counter-terrorism law into this space. And a combination of those two factors are what's really crushing any space for freedom of expression and freedom of association in a context like pro-Palestine activism.
So, big question, but what does that tell us about the state of democracy in the UK today? It's deeply worrying, and not just in relation to prescription, but as we've heard, there are these other tools as well that the government has, and there's suggestion that there are other measures being introduced or being contemplated by the government to increase this control and constraints on protest further.
Yeah, I think one point that I think keeps coming up in our discussion and elsewhere is that it's never enough. It seems like these powers are never enough. They are applied to solve a problem, but then for the government, the problem is never solved, and so the powers have to keep on expanding. So the prescription of Palestine Action has, not been enough from the perspective of the government to essentially criminalise those who aren't engaged in criminal offences related to Palestine Action, who are involved in kind of pro-Palestinian kind of solidarity organising, because that must be what the prescription is targeting, not the people who conduct criminal offences, but all the people on the fringes who are providing support for Palestine Action, as we've already spoken about. But even this prescription, it is not enough, and we've seen that the government has now discussed introducing measures which will allow the police to intervene against protests on the basis that those protests have amounted to a kind of cumulative disruption. So that protest has taken place over a number of times and created a disruption which has increased over time. Notably, this was a proposal which, as far as I can see, was proposed by Policy Exchange over, in September last year. But so essentially, this will be a new measure on top of new measures which are being introduced to ban face coverings to give police powers to ban police face coverings in protests. We've already had the Public Order Act 2023 we had the Police Crime Sentencing and Courts Act. It's becoming an annual event, and even more than every year we're seeing new powers to disrupt protest, for the police to intervene against protests. But the protests aren't going away, and they're actually increasing in number in some areas. So I think, that we seem to be stuck in a loop where it's kind of more powers. People are becoming more cognizant of there being a kind of repressive tendency on the part of the state, and I think they're actually protesting more in response to that. So we're kind of, I think things are escalating on both sides, and I think that I don't know when what that means for democracy. The more people are protesting, the more I think they're showing that they don't appreciate the government's response being to turn to increasingly repressive measures.
I suppose, to follow on from what Daniella was saying, it's a great question and it triggers 2 points from me. And the first is what Daniella said about safeguards. I think quite often we're actually grabbing at safeguards from the wrong end of a telescope here. Jonathan Hall, as current independent reviewer of counterterrorism legislation, said he wanted it spelled out to him in simplistic terms what the chilling effect of this legislation was, and that's completely the wrong way to look at A, his role as independent reviewer, but B, these measures. The question has to be, why, if measures like this weren't necessary to police the Greenham Conwyn protests in the 1980s, or to police break-ins at air bases associated with the Iraq War in 2003, why does the UK government need so many more repressive powers in this context now? And I don't see that a case has been made out positively for why the state can't deal with this sort of activity. And then beyond that, there is trying to explain how this has become acceptable in a democratic society, a liberal democratic society in the 21st century. And I think that speaks a lot more to the firewalling of politics and the idea that politicians are, in a lot of respects, isolated from the general public. We don't associate mass rallies or even public gatherings with mainstream politics anymore. When politicians meet the public, it's often in very carefully curated and stage-managed events. But we're far removed from even one generation ago in politics where people like Peter Hain were directly involved in direct action anti-apartheid protest. And there was an idea that street politics, or the politics where politicians were directly engaged with ordinary people and with protest movements, was a live part of our democratic culture. And the risk now is that we've become so far divorced from that even the value of protest in a democracy has been eroded to the point where government thinks that these sorts of interventions are acceptable. And that's really damaging to democratic culture and to the relationship between constituted power holders and the constituencies that they're supposed to represent.
And just like building on that, I think you've really hit the nail on the head there. It's just this idea that more and more tools are necessary, as you mentioned. But as we've seen, particularly in the context of terrorism, the government will always reassure us, oh, but we're the good chaps. You can trust us. And there is this classic it's called the good chaps theory of government and British kind of constitutional theory. And you see it in a good chap's approach to terrorism, a good chap's approach to police powers. You can give us all these powers, but you can trust us because we're not going to abuse them. And I think we're at the position in democracy in the UK today where we can't rely upon that anymore. You can't rely upon this discretion to be exercised in a balanced manner. And I hate that word balance because it's so loaded. Nobody ever makes a policy decision and says this is an imbalanced decision, this is a completely irrational decision. It will always be framed in terms of balance. But nevertheless, we cannot just simply give all these powers and solely rely on discretion, because we do not know what this next government is going to be like. The Special Rapporteur on Terrorism, UN Special Rapporteur on Terrorism and Human Rights, Fionnuala Ní Aoláin, in one of her last reports and last piece of published academic work, she flagged the very fact that a lot of the states that were held up as these really pro-Western allies in terms of the fight against terrorism, that the tools that those states introduced were then utilised by those governments to effectively quash any kind of fledgling democracy and to usher in a form of authoritarianism and dictatorship. So there's a clear link between counter-terrorist tools, and not just counter-terrorist tools, but those other anti-protest measures that we're seeing, and democratic backsliding. And that, I think, is a really worrying place for where we find ourselves in. Donald Trump, the value to him is essentially that he says the quiet bit out loud in terms of the manner in which he's very clearly declaring Antifa, those individuals out on the streets protesting in inflatable outfits and declaring that they are terrorists. And I think that's just a much, much more extreme example of where the UK could go, and the tools in the UK are there, I think, to do that. We're just relying upon the good chaps to not get there. But whether we're going to get there, I think, is a different question.
Yeah, I'd like to just add to that. I mean, I have noticed that every time the government has proposed new protest measures, as well as also in relation to the proscription of Palestine Action, you have international human rights organisations, including the kind of Office for the Human Rights Commissioner of the UN, actively speaking out and saying this is clearly disproportionate. You also have the Joint Committee on Human Rights parliamentarians who are saying this will give the police and the government too much powers to intervene against protests for arbitrary reasons, essentially. And I do think it's not, there is that this shows that there is pushback and a kind of official recognition from different areas that these protest measures are going too far, and that that pushback and that official commentary from human rights experts is being actively ignored. And I think that it's quite a striking situation where that is being normalized, where you have just the Office for the Commissioner of Human Rights in the UN being ignored, and that's now a normalized kind of state of affairs in British politics. I think it's also notable that the current government, Keir Starmer's government, they love to describe themselves as when we're the party of government, we're not the party of protest. And I think that also adds into this kind of increasing stigmatization around protest, as though it's somehow something that's is only engaged in by people, not normal people. It's not a sign of democratic participation. And I think in the long-term trajectory of that increasing stigmatization of protest goes hand in hand with, I think, what Colin was talking about, this just how alienated people feel from then the kind of ordinary processes of democratic engagement at the level of Parliament. And that alienation is not going to go away, and the protests are just going to keep continuing. So it will be interesting to see where the government goes with this. It can't just ban protests outright.
That's
a hell of a cliffhanger to leave things on.
But we've been talking for well over an hour now, so I do think we probably should leave it on that cliffhanger. But certainly, and maybe I should say unfortunately, there are most likely to be future developments in this area. So this might be a conversation that we can pick up again in due course. So before we end here, where could people go to find out some more about what you've written on in this area? So Danielle, is there any kind of piece that you would like to flag to people to check out on your side?
So I did write a piece for the LRB blog called Heavy Power, which is a kind of initial analysis of the proscription of Palestine Action. I've also recently had a journal article out. It's open access, so freely available, on legal studies, which is called Backdoor Executive Empowerment, and it's kind of looking more broadly at recent legislation which interferes with human rights and the way that the government has used particular mechanisms to bypass democratic scrutiny of those measures. I've also got a book which is forthcoming on UK national security law and human rights, so that will be out next year.
Cool. And who's that coming out with?
Heart.
Cool. And I think LRB is the London Review of Books, right?
Yes.
Cool. Awesome. Colin?
Right. Well, I won't add anything like as extensive as Daniella's reading list for you all. I had an article out in the King's Law Journal in 2017 called Convergences and Divergences, and I think it picks up quite directly on that point Alan was raising about what are the safeguards in the UK and how do they compare to the safeguards around banning groups in US constitutional law. And this is, again, where the good chap's theory of constitutional protections falls down, because the much more robust protections for freedom of expression, at least in theory, in the US Constitution, provide for, well, bastions to protect this sort of protest movement, and they have been used quite forcefully to push back against Trumpian measures of late that just do not exist in the same way within the UK's constitutional order, and the concerns we should have over that when we're moving into an era of banning direct action protest groups.
That sounds really interesting. Thanks both of you for this conversation. I would really love to pick it up at another time in future, but I think we've kept everyone for probably their limits of their tolerance at the minute. So I'm going to release you off and get your coffee. Okay, so great to see you again. Bye, everyone.